Hello students, welcome to the lecture on special types of contracts. And after this lecture, we will be able to learn the following objectives. Understand the contracts of agency. Describe the types of agents. Explain agent and sub-agent creation of agency. Understand the nature and meaning of contract of indemnity. Discuss the right of indemnity holder and indemnifier. Let's start with an introduction to special types of contracts. Every business enters into contractual relationships. All too often, businesses enter into contracts without the benefit of a comprehensive legal inspection. Many times, these companies forfeit important rights or become saddled by unfavorable business terms. Contracts are agreements between individuals, organizations, companies, or government entities which dictate the terms under which products will be sold or the manner in which services will be performed. While contracts may either be oral or written, most parties will memorialize their contracts in writing to reduce the likelihood of problems arising at a later date when one of the parties cannot recollect or misrecollects the terms of the agreements. Additionally, the contracting parties have a strong incentive to reduce the terms of their agreement to writing because some oral contracts may not be legally enforceable under the statute of frauds provisions found in the state codes. Let us now discuss the contracts of agency. An agent is a person employed to do any act or to represent another in dealings with third persons. The person who employs the agent and for whom such act is done or who is so represented is called the principal. The relation between the agent and the principal is called agency. It is only when a person acts as a representative of the other in the creation, modification or termination of contractual obligations between that order or third persons that he is an agent. The essence of a contract of agency is the agent's representative capacity coupled with a power to affect the legal relations of the principal with third persons. Contracts of agency are based on two important principles. Whatever a person can do personally shall also be allowed to be done through an agent except in case of contracts involving personal services such as painting, marriage, singing, etc. He who does an act through a duly authorized agent does it by himself. That is, the acts of the agents are considered the acts of the principal. Agent and principal agent. The agent is a person who acts on behalf of others. In business, this is typically the manager, chief executive officer, or another person who is put in charge of a company owned by other people. The agent is given the power to act on behalf of another person or a group of people. Principal. The principal is simply the person or group of people who authorizes an agent to act on his behalf. The principal is who gives the agent his authority to act and to make decisions. The principal does not typically make day-to-day decisions himself, but is legally the owner of the business and can give direction to the agent acting on his behalf.
A registered agent is the person or entity authorized to receive legal papers on behalf of your company. Every state requires that your corporation or LLC have a registered agent. Some states refer to the registered agent by different names. For example, agent for service of process, resident agent, or statutory agent. But regardless of how they are referred to, they perform the same functions for your company. The registered agent can be a family member, corporate officer, LLC member, attorney, CPA, or a professional registered agent company. It can even be you. A registered agent must be at least 18 years old and have a physical street address in the state where you form your company. A P.O. box is not acceptable. The registered agent's name and address is identified in your company's charter document. Some states go a step further and require that the registered agent sign an acknowledgement that they agree to accept notices on your company's behalf. Since the state mails your documents to the address you specify in your charter document, you'll want to verify the accuracy of the address you provide. If you later decide to change your registered agent, You must file a change notice with the state business entity department. Selecting a professional company to serve as your registered agent can be advantageous because they maintain a consistent address and understand their fiduciary responsibilities to your company. If your company does business in more than one state, you'll need a registered agent in each state. There are at least 3 situations where you're better off having a third party serve as your registered agent. First, if you frequently move. Second, if you want to keep your business practices private. Third, if you run your business out of your home. Professional registered agent firms keep track of important documents in business records. Most of them scan these and make them available in an online database, which comes in handy if you travel a lot and need frequent access to your files. Finally, professional registered agents can also be a great source of information as they work closely with each state's business entity's department, saving you both time and money.
Now moving on to the next topic, we will study the types of agents. Following are the types of agents. General agent. The general agent possesses the authority to carry out a broad range of transactions in the name and on behalf of the principal. The general agent may be the manager of a business or may have a more limited but nevertheless ongoing role. For example, as a purchasing agent or as a life insurance agent authorized to sign up customers for the home office. In either case, the general agent has authority to alter the principal's legal relationships with third parties. One who is designated a general agent has the authority to act in any way required by the principal's business. To restrict the general agent's authority, the principal must spell out the limitations explicitly, and even so the principal may be liable for any of the agent's acts in excess of his authority. Special agent. The special agent is one who has authority to act only in a specifically designated instance or in a specifically designated set of transactions. Agency coupled with an interest. An agent whose reimbursement depends on his continuing to have the authority to act as an agent is said to have an agency coupled with an interest if he has a property interest in the business. Servant. The final category of the agent is the servant. Until the early 19th century, an employee whose work duties were subject to an employer's control was called a servant. We would not use that term so broadly in modern English. The restatement, 2nd of agency, section 2 defines a servant as an agent employed by a master employer to perform service in his affairs whose physical conduct in the performance of the service is controlled or is subject to the right to control by the master. Sub-agent. To carry out his/her duties, an agent will often need to appoint his/her own agents. These appointments may or may not be authorized by the principal.
Hey everybody, Gene Levesque here, president and founder of Point Break Coaching, where we teach real estate professionals how to take their business and their lives to a whole new level. Thank you for watching this video today. Today's topic is on the 2 types of real estate agents. There are really only 2 types of agents that are out there, and here's what they are. Number 1, they're either passive, or number 2, they're active. Passive and active agents. I'm going to describe to you the difference between the 2. The passive agent is the one that sits back and waits for business to come to them. The passive agent is the agent that does a lot of floor time, that sits around at the office waiting for things to happen. The active agent, however, is the one that goes out to pursue new business. The active agent is the one that goes out and prospects for new business opportunities. The active agent is looking for business everywhere they can. The passive agent is sitting back and waiting for things to happen, while the active agent is creating more of a predictable and duplicatable process where they know what they can count on a regular basis. The passive agent doesn't really know how to create any kind of predictability in their business. They may do an open house and get a lead here and there. They may be doing floor time. They get an up call and they go show a buyer a property here and there. But there's no real consistency to their business. There's nothing that they can really count on. So the question for you today is this: are you a passive agent or are you an active agent? I hope you're an active agent. And listen, if you're not and you want to become one, request a free coaching call. And then I will personally contact you to set up your free coaching call. I will explain to you everything that's involved in the coaching program, and then you decide if it's a fit for you. I'm looking forward to the opportunity of working with you real soon. We'll see you on the next video.
Rights and duties of agents. Rights of agents. Right of retainer. Agent has the right to deduct the amount which is due to him by principal from amount payable to principal. Right of stoppage in transit. In case where agent is personally liable, he has right to stop the goods in transit. The good may be moving towards customer or principal. Right to claim remuneration. As per the terms of agency contract, agent has rights to claim remuneration. Right of indemnity. Principle of indemnity gets operated between principal and agent, where principal is implied indemnifier and agent is implied indemnity holder. So agent can make principal answerable for all types of sufferings. Right of line. Agent can exercise right of line, but Contract Act has not specified whether it is general line or particular line. Therefore, the nature of agent's line depends upon mutual understanding. Duties of agents. Agent should follow the instructions given by the principal. If the agent comes across any complicated situation, he has to communicate that situation to principal and his advice to be obtained. Agent should behave in his capacity as agent. He should not run the transaction in his own name. Agent should not make secret profits by utilizing reputation of the principal. Agent should safeguard property of principal, particularly upon happening of events like death of principal, insolvency of principal, etc. Agent should maintain proper accounting records to enroll the transactions run by him. Agent has to remit amounts to principal properly. Agent has to remit amounts to principal properly. Agent should not carry on delegation. Liabilities of agents. Actually, agents bind over principal to his activities, but there are some situations where agent comes across personal liability. Those situations are as follows. Terms of contract of agency may create personal liability to agent. The tradition which is in operation in that particular type of business may also create personal liability to agent. If agent does not behave in his capacity as agent and then runs the transaction in his own way, personal liability arises. When agent acts for foreign principal, agent is personally liable. Pretending agent is personally liable. When agent acts for principal who has not come into existence, agent is personally liable. In case where principal cannot be sued, customer sues agent and thus agent is personally liable. When agency is coupled with interest, then also agent is personally liable. Let's now talk about the agent and sub-agent creation of agency. An agency is a consensual relationship created by contract or by law where the principal grants authority to an agent to act on behalf of the principal to deal with a third party. An agency relationship is fiduciary in nature, and the acts and words of an agent exchanged with a third party bind the principal. However, a principal can be a party if he/she becomes a surety. If an agent employs a sub-agent for his/her principal and by his/her authority, then the sub-agent is the agent of the principal and is directly responsible to the principal for his/her conduct, and if damage results from the conduct of such sub-agent, the agent is only responsible in case he has not exercised due care in the selection of the sub-agent. An agent is responsible to the principal for the conduct of a sub-agent with reference to the affairs of the principal entrusted to the sub-agent. However, a sub-agency cannot rise higher than the general agency, and when that general agency ceases to exist, it will automatically dissolve the sub-agency. An agent is not liable to third persons for the misfeasance or malfeasance of a sub-agent employed by him/her in the service of his/her principal, unless he is guilty of negligence in the appointment of such sub-agent or improperly cooperates in the acts or omissions of the sub-agent. Sub-agency refers to a specific client representation relationship between properties, listing broker or real estate agent and another real estate broker or agent who brings the buyer to purchase the property. In sub-agency, the agent bringing the buyer is actually working for the seller as a sub-agent of the listing broker. This is important as the agent working with the buyer actually owes fiduciary duties to the seller, not the buyer. Contract of indemnity. Indemnity literally means making good the loss or compensating a person for any loss. A contract of indemnity is a contract by which one party promises to save the other from the loss caused to him by the conduct of the promissory himself or by the conduct of any other person. The person who promises to make good the loss is called the indemnifier, and the person to whom the promise is made, that is, whose loss is to be made good, is called the indemnified or the indemnity holder. Nature and meaning of contract of indemnity. A contract by which one party promises to save the other from loss caused to him by the conduct of the promissory himself or by the conduct of any other person is called a contract of indemnity. The person who promises to compensate the loss is called the indemnifier, and the person who is so promised is called the indemnity holder. According to the definition of indemnity, the loss to be made good must be caused either by the conduct of the promissory himself or by the conduct of any other person, and so if the loss is caused by accident or by the conduct of the promise indemnity holder, there would be no indemnity. However, the courts have taken the view that this interpretation is not correct and that indemnity cannot exclude insurance. A contract of indemnity being basically a contract, it has to possess all the essential elements of a valid contract such as free consent, lawful consideration and competence of parties to enter into contract, etc. Further, a contract of indemnity can be either express or implied. An implied contract of indemnity can be inferred from the conduct of the parties or the circumstances of the case. Rights of indemnity holder. As we have already seen, contract of indemnity is a contract where the indemnifier promises the indemnity holder to save the latter from any loss that may be caused to him under the contract. From this, the rights of the indemnity holder can be stated as if the indemnity holder has to pay any compensation to any party in any suit in respect of any matter pertaining to which the indemnity applies, he can recover the same from the indemnifier. He can recover from the indemnifier all costs of suit which he has to pay to such third party, provided he has acted in good faith under the authority of the indemnifier and as per his instructions. If any amount has been paid by the indemnity holder to any third party in any such suit by way of compromise, he can recover the same from the indemnifier, provided such compromise was not contrary to the orders of the indemnifier. Rights of indemnifier. The Act is silent as to the rights of the indemnifier. However, his rights are similar to the rights of surety under contract of guarantee.
Hello everyone, my name is Lucian Zaborowski, and today we will be talking about professional indemnity insurance. What is it, and why you may need it for your business? Today, my guest is Robert Hartley. He is one of our experts on this subject. He is a product manager here at Simply Business. So, welcome to you, Robert.
Thank you, Lucian.
So, let's get right to it. In simple terms, in simple words, what is professional indemnity insurance?
Well, professional indemnity insurance, or PI insurance, is insurance that protects you against claims from dissatisfied customers. So if your advice or design or a service results in financial loss to your customer, then you may be subject to a professional indemnity claim. But it's also important to remember that even if you've done nothing wrong, some clients will be unhappy or disgruntled, or even just try it on and try and get some money out of you, in which case you will have to pay the defence costs to protect yourself, and PI will also pick up those defence costs.
Is professional indemnity insurance actually required by law?
Not by law exactly, but you'll have certain regulatory bodies, such as the solicitors, the body that regulates solicitors. They require that all solicitors in the UK have PI, and the same goes for accountants and architects.
Does professional indemnity insurance cover only for financial damage, or is it physical damage as well?
Well, the professional indemnity is covering the financial damage to your client from the service or advice that you've given that was negligent. The physical damage will be covered by public liability. So if the customer trips over a bag, say, and injures himself, that would be public liability insurance.
What professions are commonly associated with having this kind of insurance? Could you list some of them?
Well, for PI, as I said, there'll be some that have to have it. So the regulator or the institute that provides certification will demand it, like solicitors, accountants, architects. But then you also find that a lot of customers that we have, like IT contractors, even though it's not required by any regulator, their customers require it of them, and then it becomes a necessity.
So let's say I am an IT technician, and I, instead of setting up a computer, or actually instead of advising a customer on setting up a computer, I do it myself. I do it manually. So does that make a difference between my liability from professional indemnity point of view?
Yes, it would make a difference. If you are literally brought in to install a machine,
Yeah.
And you're not giving any advice on the type of machine that they require or the software, or you haven't designed any of the software, you're literally plug and play, then that doesn't require professional indemnity. You probably would require public liability, for instance, in the case then where you've got your tool bag lying around, your customer trips over it and hurts himself or damages something, then that would be your public liability.
Okay.
But in the sense of just plugging in something and constructing it, that doesn't require the professional indemnity. Any time that they give you have an element of advice,
Yeah.
or you've told them, yes, you definitely need this machine will manage your website host, and then suddenly your website crashes, then you failed in your advice.
Sure.
That's when professional indemnity would kick in.
Does it make a difference if a person works from home? I would think not, because obviously the location doesn't really matter. You're still giving advice, correct?
Absolutely, that's
Yeah.
right. And I mean, even today, especially particularly with IT developers, you could actually be working for someone in Brazil or America or Australia giving advice, and you'd still require professional indemnity insurance.
So what does the level of professional indemnity insurance actually depend on, would you say?
A lot of the time, it's driven by the regulator or the client of the contractor, and you'll find that it's typically £1 million is the sort of the request. But if you don't have to have it and you're buying it to protect yourself because you have these exposures and you're not demanded by a regulator, the key thing is to think about what the financial loss could be to your customer from the advice that you're giving. So it could be, so you think, oh, it might only be a few £1,000s. Well, we start at £50,000 as the low level limit. So that might meet your need. It's very difficult to say without knowing your exact scenario. But it could be that you're working on some projects that requires £5 or £10 million, in which case that you can buy up to those limits as well.
On average, would you say that the professional indemnity cover is more or less expensive than public liability insurance?
Well, for professionals, it will be professional indemnity. The majority of professionals are not exposing themselves as much to public liability claims. However, it's important to still be covered against those. A lot of contractors, for instance, like an IT contractor, his risk from PL is more likely to have leaving a bag lying around, or as opposed to a construction site where the PL risk is much greater.
What are some of the common claims that you see for professional indemnity insurance? What are people claiming for?
Well, mostly from the people who acquire it. So accountants who give bad tax advice. I've seen an architect who designed a bridge in the US, and it collapsed because they hadn't accounted for the weight of the vehicles going over, and that was a very expensive claim. And anything from a very small fraudulent claim against an IT contractor that we then threw out because there was actually no real basis for the loss.
Rights of indemnity holder when sued. Section 125 lies down that the promised indemnity holder in a contract of indemnity acting within the scope of his authority is entitled to recover from the indemnifier all damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies. all costs which he may be compelled to pay in any suit if, in bringing or defending it, he did not act against the orders of the promissory and acted as it would have been prudent for him to act in the absence of any contract of indemnity, or if the promissory authorized him to bring or defend the suit. All sums which he may have paid under the terms of any compromise or of any such suit, if the compromise was not against the order of the promissory, and was one which it would have been prudent for the promise to make in the absence of any contract of indemnity, or if the promissory authorized him to compromise the suit. It should be noted that a contract of indemnity is a species of the general contract, and as such, it must satisfy all the essentials of a valid contract like free consent, capacity of parties, lawful objects, etc. Thus, if the object of a contract of indemnity is unlawful, it will be void. When the liability of the indemnifier commences, there is a conflict of opinion among the various high courts. Some have held that the liability of the indemnifier commences only after the indemnified had discharged his liability. However, others have held that the indemnity holder is entitled to be indemnified even before he has actually discharged his liability. It would be realized that the latter view with indemnified or indemnity holder can compel the indemnifier to indemnify before he has actually discharged his liability is more logical and correct. Rights of the indemnifier. The rights of the indemnity holder are the duties of indemnifier, and the duties of the indemnity holder are the rights of the indemnifier. There are not prescribed any specific rights of the indemnifier either in Nepalese law or in Indian law. However, he is not liable for indemnity if indemnity holder acts negligently, if indemnity holder is acting with the intention of causing any loss or damage, if he is acting against the instructions of the other party, promissory. Duties of indemnifier. The duties of an indemnifier arise in the following circumstances. There must be a loss in accordance with the contract to make the indemnifier liable. There must be an occurrence of the anticipated event. Without any occurrence of the prescribed event, there is no indemnity by the indemnifier. Where the right of indemnity is used by the indemnity holder prudently and the instruction of the indemnifier is not contravened, or when there is no breach of contract. If the costs demanded by the indemnifier are not caused by negligence, haphazard behavior. Now, in the end, let us summarize what we have learned in this lecture. A contract of indemnity is restricted to cover the loss caused by the promissory himself or by a third person. The principal does not typically make day-to-day decisions himself, but is legally the owner of the business and can give direction to the agent acting on his behalf. The general agent possesses the authority to carry out a broad range of transactions in the name and on behalf of the principal. These agents are sub-agents of the principal if the general agent had the express or implied authority of the principal to hire them. Principle of indemnity gets operated between principal and agent, where principal is implied indemnifier and agent is implied indemnity holder.